Student, now we are having a second video, and in this video we will talk about how can a judge be removed from his office. A judge of the Supreme Court may be removed from his office before the expiry of his term by the president, but on the ground of proved misbehavior or incapacity. If he will show misbehavior or incapacity towards his work, then president can remove a Supreme Court judge. But the president shall make such order for removing a judge only after an address to each house of the parliament. Clear? Student, now let's start our next topic, that is structure of the judiciary. The Constitution of India provides for a single integrated judicial system. And this means that unlike some other federal countries of the world, India does not have separate state courts. Clear? The structure of the judiciary in India is pyramidal with the Supreme Court at the top. After that we are having High Court, and after that the District Court is there, and after District Court we are having subordinate courts. Firstly, we will discuss about Supreme Court of India. So its decisions are binding on all courts. Clear? If any decision is taken by Supreme Court, it has to be binding on all courts. So it can transfer judges of High Courts also. This is also a feature of our Supreme Court. It can transfer the judges of High Court. It can, it can move cases from any court to itself. Fine. And next we are having, it can transfer cases from one High Court to another High Court. We know that every state is having a High Court, and here I want to tell you one thing. Some states are having 2 or 3 states also are having only one court. Clear? It doesn't mean that we are having 29 states, so we are having a 29 High Courts. No, some 2 or 3 states are also having their common one High Court also. Clear? So next we will talk about High Court. High Court can hear appeal from lower courts. Lower courts like a district courts and subordinate courts. Clear? Next we are having, it can issue writs for restoring fundamental rights. It can deal with cases within the jurisdiction of the state. And next, it can exercise superintendence and control over courts below it. Clear? The third, we are having district court, as we are living in the districts of Ludhiana. So any cases has to be discussed in the district court only. Firstly, we are having deals with cases arising in the district. It deals with the cases arising in the district. Okay, second one of district court feature is it consider appeals on the decision given by lower courts. Third, it decides cases involving serious criminal offences. And after the district court, we are having subordinate court, and it consider cases of civil and criminal nature. Clear? Student, let's start our next topic, that is the jurisdiction of Supreme Court. If we talk about Supreme Court, we know that it is a very powerful court anywhere in the world. However, it functions within the limitation imposed by the Constitution. Let's start its first function, that is the original jurisdiction. Under this, it settles dispute between union and states and amongst state also. Second, appellate jurisdiction. Under this, it tries appeals from lower courts in civil, criminal and constitutional cases. If we are talking about third, advisory. Under advisory, it advises the president on matters of public importance and law. Okay, first original jurisdiction. Under this we are having some writs also. Student, it can issue writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto to protect the fundamental right of the individual. These writs we have already discussed in our previous chapter, so its importance is also there in this chapter also. We are supposed to learn all the writs. Clear? Students, you know that it has some special powers also. It can grant special leave to an appeal from any judgment or matter passed by any court in the territory of India. Fine. So this we have discussed the jurisdiction of Supreme Court. Students, we know that Article 137, according to this article, the Supreme Court shall have power to review any judgment pronounced or order made by it. If we talk about Article 144, all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Students, here I want to tell you, in political science in class +1, articles are very much important. So, particular articles which are highlighted in your books, you have to do in anyhow. Okay, side by side I will guide you whenever we'll complete the chapter. Student, let's talk about judicial activism. Judicial activism has become popular because it provides justice to the poor and innocent. Due to judicial activism, poor people are able to get justice, but sometimes judicial activism can lead to a conflict between the judiciary and the executive. Clear? So, judicial activism is against the theory of separation of powers. Student, the chief instrument through which judicial activism has flourished in India is public interest litigation. I hope you all are familiar with this term. That is, in short, can be known like a PIL. Fine, public interest litigation or social action means SAL. So you are having two abbreviations here: PIL, public interest litigation; SAL, social action litigation. PIL, you are already informed about this thing, but SAL is a new term for you, so very careful. You have to listen this. Social action litigation is known as a SAL. So what is PIL or SAL? We will do in detail now. How and when did it emerge? In normal course of law, an individual can approach the court only if she has been personally aggrieved. Clear? So that is to say, a person whose rights have been violated or who is involved in a dispute could move the court of law. This concept underwent a change around 1979. In 1979, the court set the trend when it decided to hear a case where the case was filed not by the aggrieved person but by other on their behalf. Clear? So as this case involved a consideration of an issue of public interest, it and such other cases came to be known as public interest litigation. Clear? Student, now we will move to the next topic, that is judicial review. Fine. So we know that in our India there is a written constitution, and in the written constitution the wording and language is sometimes technical, which is difficult to understand for a common man. Clear? So for the people or proper interpretation of the constitution, the power of judicial review is necessary. Clear? Judicial review is necessary for protecting the civil liberties also. It has rightly been said that rights and liberties of the citizens are not unlimited. So for the safety and security of the state and keeping in view the public interest, the government may impose some limitations on them. Clear? Whether these limitations are just or unjust, it is the jurisdiction and duty of the court to decide, which can be done only through the power of judicial review. Clear? At last, with the completion of this topic, students, our chapter is also finished. Fine. I hope you understood the chapter in proper manner, and you all are required to do the important terms and back exercise of this chapter in your fair notebooks. The chapter level resources you are required to revise. Fine. Thank you so much.